if I did place you under the 180 days requirement, this court would be failing its duty. How can the defense not be ready, right? You attempt to burn down someone's home, that is as serious as it gets. Right, trial docket. Let's start with that. Sir F. Solomon, and he's representing himself on this. And Mr. Ham?
Yes, sir.
Y'all ready?
We need to give with conversation with him as he was talking about needing to subpoena some documents, and we need to see if he's actually ready.
Well, your main reader. All right. And Anthony McCullough.
Judge, if I had my purposes of trying Reader or McCullough, I'd rather try McCullough. I'm still ready for Reader if you want to choose it, but
That's what we're going to do.
I have a witness that I had to find that been gone for months, and I finally located.
Reader is first. Reader is going to be first.
Yes, sir.
But McCullough, you ready? And then, as far as you know, it's 1,500 days. I mean,
Yes, sir.
how can the defense not be ready, right? I'm talking about the defense. I don't know where Tom is. He's not here, but it's Troy Steins is next.
Judge, from my understanding, you allowed that to be reset on Friday.
DeLester Brister.
Present, Judge, and I have a sort of qualified already.
I don't understand what you're saying.
I'm supposed to have surgery Thursday in Houston. Thanks for trying. So I need to go over there Wednesday, and therefore I'd like to have an extension or resetting.
Mr. Ham, are y'all ready on, how long would that take, you think, to try?
That was a short one, Judge.
Okay.
Maybe able to work within the time that he had.
Okay. Robertson and Tommy Williams. Frederick Wills.
All three of those are thinking I'm ready.
Okay. Can you try them at the same time?
I can try.
Penland Falk.
I'm ready on that one, Judge. And Judge, Mr. Falk called this morning and said that he was in the emergency room. I don't know if you want to call him. I told him that he needed.
Isn't Langston Adams the attorney?
Sir. Yes, I did tell Mr. Falk that he needed to submit some paperwork for the hospital to get with his mom. Again, I don't know if I want to finding.
Ronald Pulse. Mr. Coleman on Ronald Pulse, y'all ready?
Yes, let's have a case left over murder trial starting this afternoon. It's essentially a priority setting.
I thought you were working over here. No, really? You're working both courts?
Judge, that's just a refresher memory. We talked about it last week.
Yeah. Like I can remember.
No, Judge, this is
The faces.
this is the last trial that Mr. Coleman has left over from the 2 second. There were 4 co-defendants.
That's right.
And so he's trying that this.
The last of the 4,
These are just cases that we need a new announcement on now that Mr. Coleman's on the case.
Who's the prosecutor on that one? Who's the prosecutor over there on that case?
On the murder case?
You're going to be.
Yes, sir.
That's Pauline Neely
Same announcement.
Rare that he was here.
and Richards and Murchison.
Continuances in both of those.
All right. So Jermaine Reader is first, McCullough is second, third, Robertson's fourth, Williams is 5, Will is 6. That's that order. Thank you. Here's the 5.
Please bring Mr. Solomon out.
No, yeah, we're not going to deal with him until we have to deal with him. David Booth. Yeah, thanks. David Booth. And he disposed of. Okay, disposed of. Then this is the only other pending case on Booth, I guess, right?
I'm good.
I'm looking at David Booth.
Oh, you want to?
No, we got an announcement. Yeah. It's an aggravated assault with a deadly weapon. It's an announcement today.
Oh, okay, that's what I thought. I thought you put me on the trial today. Yeah. Hey, I had to work some because if you put me number 1 today on that one.
If I'm not mistaken.
Yeah, I thought you said.
No, David, no, we already did that already. We're into the regular docket. I'm just trying to get this done.
All right, I got him. Judge. He's in the booth.
If I recall, you had already did I think you had an MTRP on him.
Yeah, it was disposed of. What happened on, what was the disposition?
I thought you gave him 2 years, but I could be wrong. I'm going off the top of my memory, but I do remember you doing the MTRP.
Yeah, I'm looking at, it says MTRP is disposed of.
And
So this is what's left.
yes, sir. So I had that one with Mr. Laird. So I just need to confirm with Mr. Laird.
Why are you pointing at me and calling me name?
I know, right?
What are we doing?
My client recalls that with the MTR, I was supposed to get rid of this case too, but what you said, yeah, because the judge has already sentenced him on TRP.
Okay. And I was supposed to,
Years.
He received 4 years, that's right, 4 years. Yeah.
and I agreed to get rid of an aggravated assault with a deadly weapon. I gotta look at that.
Take a look, I'm just,
On site for me.
that's what he was telling me.
I'm gonna look at.
Was the MTRP based on this event?
I think so, if I'm not mistaken. Yes, sir. Yes, sir. But I do remember the hearing, and I did remember you made a decision. I just couldn't remember the exact time. And then while we waiting, I'm gonna sign up, Sandy, that's a plea. I'm gonna get that done today.
Okay.
That's the next one you got, but I need to sign them up.
Which docket is it on?
That's same
Announcement.
announcement, yeah, that's gonna be a plea. I'm gonna sign that one up as we speak.
Oh,
As we speak. But on this one, Mr., that was 4 years you did.
what was he on probation for? Do you remember?
That was for,
It had to be,
Fraud, Judge.
that's 4 years, so it was above a state jail felony, so he must have prior
This is the
state jail,
this one.
unless there's a prior conviction.
okay.
What did y'all decide, Mike?
Judge, I'm showing I've already dismissed for robbery on him. I don't know what he's talking about this.
This is aggravated.
I know. He's from Lucas, Texas.
It says striking the victim about the head and body with a bike chain and in the right hand with a bicycle chain and stabbed her on the left side of her neck with a mail opener type knife. Was that the basis of the revocation in the road?
Yes, sir, to my knowledge.
On the judgment, it says he pleaded true to count 5, which was, count 5 was a failure to report to the probation.
You're gonna be accurate with me, because, I mean, we'll check it, and
I'm looking, Judge. I had
That-
notes.
that wasn't the ground we revoked him for.
The police
So,
paper.
yeah, we didn't revoke him for this allegation, this indictment. It's for administrative matter. Take your hat off, please. This is a court of honor. Thank you. While we're waiting, what about Cyrus Sandy?
I'm signing it up right now. That's okay. That's gonna be a plea.
What about Dan Shelton?
He is in, I'm sorry. Good.
Said,
Oh, he said it? Yeah, and I got a copy from, this plea, Jack, I'm gonna give it to you. On Dan Shelton,
Yeah, what about Shelton? He's got more than one. He's got 2 cases.
but here you go.
So it's the same thing.
Right, but here's what I think I got this for you. 1, 2.
You know what?
Here you go.
Did you pull those already?
yes, sir.
Yeah, she pulled them. I don't have the files.
Okay, but that was, what that was is from Judge Holmes's court, the finding of incompetency. That was in 2025, in September. That's on Shelton, Dan Shelton.
Yeah, but he didn't commit the crime until March 17th of 26. That's the key thing. He's finding in September of last year, he was incompetent. That doesn't mean he didn't gain competency.
Yeah, but
And when he committed, I don't know. But I mean, it needs to be determined, the event
right.
was half a year later. So, I mean, they gain competency, you know that. They can do it the next day or the next month. But did you want,
I just want to get it to you for the file.
for me?
Yeah,
All right.
that's for you.
I don't see anything we filled out for a plea agreement on the MTRP. Did you do it? I'm not seeing any agreed plea on it. So I would put it to that.
Can you pull the MTRPs?
Judge, I'll have to go look and see if we still have the file. It's,
Mike, can we come back to him?
oh.
Yeah, we need to come back to him because I don't see anywhere on anything that says we agreed to that with record. May have to get the plea out, whoever did the plea.
Okay, no problem. Just let me sign Mr. Sandy then. That is a plea for certain. I'm gonna sign him up now.
Okay, just have a seat in the box there, sir. So,
And I'm signing as we speak. Let me go get him.
David, and then,
I'm signing up Sandy now.
what'd you say on Turner? David Turner? And that's an announcement, it's family violence.
Can I have just one reset on him only? And I'm going to sign up Mr. Sandy now.
Hold on. Yeah, he's filing motions on your behalf in this file. He's got a motion for class A misdemeanor, state jail felon from the state jail felony. The only problem this is 3rd degree felony. It's going to be hard. It's going to be hard to reduce the 3rd degree felony under 1244A. No, that doesn't work. That doesn't stop them.
All right, guys,
Pick that up.
I'm signing up Sandy now.
Thank you. Don Craig.
There's next going to be a dismissal as soon as the victim gets the non-prosecution signed. So I guess if we just do a reset until they can get that done.
My staff left, the lawyers are gone, we're closed, we're closed. Okay, so you're saying Sean Craig is to be dismissed?
Yes, sir. It is. I don't know if it's going to be done today yet because I think he's.
Who is the,
Larry.
okay, he seems to be busy.
He's fine.
What about Glenn Cunningham?
That one actually has already been reset. Hired Scott Ray.
Glenn, two cases, Gary Williams.
We were ready to go.
And the other one is
Ready to go on it.
all right, we need Gary McWilliams. He's in custody?
Yes.
Thank you.
They're both just, so it's 205 plus restitution. So I say.
You're Gary McWilliams? You need to go in front of this lady. Thank you.
Information, swear or do on right hand. I need a much darker than that. It's okay. Oh, well, yeah.
He doesn't think that today.
Right here, don't tell me.
Sorry.
Okay, better.
You didn't want today reset until he could get it.
Yeah, I'm gonna get it first.
23C138 call, the state of Texas versus Gary Michael McWilliams. That's you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 21st, 2023 in Jefferson County, Texas, you committed the state jail felony of theft of material, and it looks like it's copper. You understand what you're charged with here?
Yes, sir, I do.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 1 year in the state jail. Is that your understanding of the plan?
Yes, sir, it is.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
They got caught at the scene, so the people didn't lose their stuff, right, everybody?
They caught him in the act.
Okay. If I follow this agreement, you have no right of appeal, and you will be given credit for all time you've served in accordance with this case.
Yes, sir.
Have you pleaded this, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Show you what's marked as State's Exhibit 1. Did you sign that, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, the indictment, when you read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived. I will follow this agreement. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of theft of material, namely copper, and following this agreement, you were hereby sentenced to confinement with state jail for 1 year. Do you understand what has happened today, sir?
Yes, sir.
Okay. Is there anything else you have pending?
No, sir.
Thank you.
I have Christopher Sullivan. Oh, ran out of blue. I'm completely out of blue. Nope. I got 1,000. Some of that lady, thank you.
So right hand for me. You swear or affirm your whole thumbprint, flat on the box right here. Get it one more time. Place it flat right there. Okay? You go say.
Okay. 23C1792, the state of Texas versus Christopher Salinas. Present, Mr. Duke, your attorney and the state's attorney. Does the defendant waive a reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about July 10th, 2023 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Let's see. It says intentionally and knowingly damaging or destroying tangible property, namely a chain fence, by cutting the fence with wire cutters. And that was the loss of $2,500 or more, but less than $30,000. That constitutes a state jail felony. Do you understand that you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can also be assessed. Do you understand the punishment range? An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the state jail. Then that would be suspended. You would be placed on regular probation
Judge, there's also restitution.
for up to 5 years. I hadn't even got to that part, but I don't see how much rest. And it says restitution, but there's nothing filled in.
We show $9,549.
Let me try to work this device here. Is the eraser. All right, once again, it's
$9,549.
restitution equals $9,549, and that would go to the victim in this case as alleged in the indictment. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Have you pleaded this guilty or not guilty? Are you pleading guilty of violence that is on your own free will and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign? Discuss it with your attorney. The contents all correct. State's Exhibit 1, without objection, it's submitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily. You know what you've been charged with. If you were guilty of the crime charged in any lesser included offenses, you were giving up your rights to and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. This is part of the record. Pre-sentence report is waived. I'm going to follow this agreement. One thing I want to ask is, you're going to be ordered to pay back restitution, the loss, in the amount of $9,549. How are you going to do that?
I got on the job.
When was the last time you had a job? Years?
No, it was,
You're homeless though, aren't you?
I was living with my girlfriend. I had a job. I was a home provider for a friend's daughter. I'm gonna see if I could get that job again.
Okay. Are you a licensed home keeper?
It was a friend's daughter. She was sick. I was just washing the clothes, maintaining the house.
What do you have a skill for?
I'm a great handyman. I was working out in the oil fields. I just need
Well, what were you making then? A lot, probably.
27.
I was gonna say 30 at least, but okay. Well, that's 50 grand.
Yeah, I could get that job again. It's because ever since I lost my vehicle, I've just been doing bad. I've been trying to stay up, but it's just, everything just kept falling down on me, and I'm still happy. Like, that's one thing my life hasn't
Well, let me
done.
just give you a word of advice is your story of life isn't really much different than ours. I mean, we got good days and bad days.
Yes, sir.
And it's like 2 steps forward and 1 step back in everybody's life.
Yeah, mine was like 10 steps back and 1 step forward.
Well, why was that?
Ever since my childhood, I've had a rough life.
Welcome to planet Earth.
Yeah.
Everybody's got a story.
Yes, sir.
I wasn't born in a millionaire's home and
Yes, sir.
but anyway, the point is that your story is not much different than probably most people. The point is, this is fixable, but you gotta fix it. How many criminal convictions do you have?
On top of my head, it's weird. It's like, it happened when I was 17. It happened when I was 27.
Well, I know, but the 17,
It's like a 10-year.
you had 12 years of schooling, come on. You know, if we make choices, we make good choices and bad choices. When we make good choices, bad choices, we get punished. And we really, you're, from what I take it here, from looking at this, you're smart enough guy, you're wise enough to know right from wrong and what is the best choice and what isn't. Fix this.
Yes.
Move on with your life, get the trade, and if you get into the oil business out there, you're gonna make a lot of money and you'll be able to then do good things with it rather than bad things. Okay. I don't seem to know that. Anything else to add by anybody? So again, there is sufficient evidence supporting this guilty plea. I'll find you guilty beyond a reasonable doubt, and I'll find you a reasonable doubt of this state jail felony. I'm following this agreement. You were hereby sentenced, confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. You do well, fix this, pay this back. It will be shortened in 1/3,
Okay,
which is a year and 2/3,
okay.
18 months. Essentially 18 to 20 months. You must pay restitution in the amount of $9,549 to the victim complainant, as that name is here in the indictment. If you failed, your probation could be revoked and you can be sentenced up to 2 years. How much time was he have?
I would have a 5 months back to.
You would know better than anybody, because I'm sure you don't forget that.
Yeah.
Nobody ever does in this room who's going through it. But you don't want 24 months.
Yeah, I don't.
Fix it, move on, make a life that's independent and that is of doing good things.
Yeah.
Anything else? That is all. Good luck. You're going to see the probation officer. He's going to go over all those terms, and you can move on.
Going back to that, John Craig, when she wasn't here, we're thinking we're going to reset that a couple of weeks till we get the prosecution in the district. So,
Okay, Sean Tremaine?
yes.
And did we need that person out?
No, sir.
Okay,
Just a couple of weeks till I can,
is 2 weeks good?
whatever you want, 2 or 3. As soon as the victim signs a non-prosecution agreement, they'll do an order of dismissal. We'll even need the victim to be back.
Okay, well, when is that going to be done?
I hope so. 2 or 3 weeks should take care of it. Whatever you think's a normal.
I mean, is it ready to go and be signed?
Yeah, we're just waiting. We're just
They
waiting.
show up at my office, what the process is they contact me, I go talk to them for briefly just to make sure that's really what they want to do,
Yeah,
not somebody
yeah.
personal. And
But
we
it's
do it that
generally
day.
it's what
We do
they-
it that day, yeah.
It gets done, generally. Very few times is there, oh, we had this all wrong, we're going to go about our business in a different way. Yeah, generally, to get it done,
Yes.
when they understand and see if face to face. And is 2 weeks going to be good, do you think, on that?
Yeah.
Okay, all right, we'll review it in 2 weeks.
Thank you.
Thanks, Don. What else, Don?
That's it. That's all I've got.
Okay, I have Nathaniel Clark.
That's please, Jeff.
That's, it looks like
Yeah.
Brendan Manning, Mr. Manning.
He's signing in the back.
He's at the back. William Langston is which one?
That's, Cyrus. He's ready right now.
Come on up. Cyrus Sandy.
Yes, sir. He's done. And then on who we got him figured out too.
Okay.
But that is sent to you. Let me get Mr. Oh, my guy, Mr. Falk, that's on the trial docket.
Yeah.
In the hospital. Are you gonna reset him or?
Well, I don't know. I did.
Is he gonna be reset?
Things in case we do not get any paperwork from the hospital. You know, he says he's in a hospital, but I don't have any paperwork to back that up. So
Yeah.
we do need to make some findings.
What kind of fine?
And just in
Do we
case-
just need to call his name and call him in the hallway that way in case he doesn't bring anything and we file?
That's it, if he doesn't.
I'm not following this really well.
Because if he's in the hospital, we know he's not coming. If we call his names, I mean, nobody call.
Well,
Okay, but
But what if
But
he doesn't produce any paperwork from the hospital? I have nothing to back that up other than him calling me on the phone.
there's nothing we can, what can I do right now about that? I can't produce
The state's
paperwork, do you?
We're asking that we call his name in the courtroom and outside. If he does produce the paperwork, then that will be okay. But if he doesn't and we file something,
So he's not going to be out there. So there's no answer. Then what do we do next?
we're waiting, we're giving him time to produce something as Lacey requested. And if he doesn't,
Well, how are we doing that? If he's not here, if I order him to do it, I'm not communicating directly with him. How do I do that?
Judge, in the past, you've made tentative findings on a bond forfeiture. If they submit paperwork, then we don't.
Is we're going to treat this as though it could be a bond forfeiture.
And
Because he's not here, he's saying he's in the hospital, but we don't have verification of that in our hands.
correct.
I
So,
understand.
yeah, so
That's
if he submits paperwork, obviously we won't do the warrant. But if he's not able to produce paperwork, then we'll follow through with.
Let's take this man, then we'll go to that other case.
Sandy.
Okay.
And we'll make findings.
Yes, ma'am.
Okay, right now, Chris. I need the whole. I'll just start right there. Okay, one more time. Okay.
Good morning, Judge. How are you?
I'll let you know.
Okay, fair enough.
So,
26 CR 410 is called the State of Texas versus Cyrus Sandy. You're Sandy.
Yes, sir.
Yeah.
Good.
Generally, they don't mistake me for a girl. That would be, but you had it narrowed between one or the other, and it was a 50-50 shot that you had. you're here with Langston Adams, who is your attorney. And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
I see we got two paragraphs here with an enhancement. Are we passing on the enhancement part?
We are,
Okay. In summary, this indictment in paragraph 1 alleges that on or about March 2nd, 2025, in Jefferson County, Texas, committed a third-degree felony, fraudulent use or possession of identifying information or items, which is in a number of more than 5 but less than 10 pieces of information. And these are credit card numbers and debit card numbers. And that was without the consent of the people whose names were there on those items and without their permission. So this is a third-degree felony, which means you're looking at no less than no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
yes, sir.
Agreement's been reached in your case where you would be pleading guilty, sentenced to 7 years in prison. Then another case, 25 CR 1443, would be dismissed. Is that your understanding of the agreement?
Yes, sir.
Why this here too, and the numerical 7, just so that there's not a 7 years confinement, and the other case will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution?
I believe so, Judge, but let me check for you. Says we have not received any claim, Judge.
How do you plead to this charge? Guilty or not guilty?
Yes,
Are you pleading guilty voluntarily and because you are guilty?
yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes, sir.
Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
Okay.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to speak, appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence was waived here.
Yes, sir.
I will follow the agreement and find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony, fraudulent use or possession of identifying information. Items, got a correct indictment here of the caption. It's got items less than 5 but more than 10, which arithmetically can't happen. Correct. It's in the caption, so it's not part of the body, but it's still wrong. In the body, it's correct. All right, that's been corrected. There is sufficient evidence supporting this to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt of this crime. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 7 years. And you will, of course, be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
All right, that is all.
Thank you, Judge.
All right, take it easy. Mr.
I've got David Booth and David Turner still left.
I thought he was gonna reset her on Boo. He's adamant saying that he didn't do that, but I want to bring him out so you can hear. Let me get Mr.
Wait. One thing at a time.
You want,
Is it Turner that,
that's the one I was gonna ask, just one reset on Turner.
where is he? Back there?
He's in the back.
Okay, State? Okay, I'm gonna grant that 1 week resetting on Turner, and the other is,
You want Falk? I'll get this here. I can get Booth if you want.
which one is the one that's theoretically in?
On the trial, like I just need to pull that file.
That's Mr. Falk.
Okay, let me know some findings on him real quickly.
It doesn't
Where's my
matter.
file? Am I?
Means he's at the hospital.
Okay, we're talking about Kenlon Falk, correct? In 25 CR 1228, the defendant is indicted with the second-degree felony of aggravated assault with a deadly weapon. That the prior convictions There are 3 prior felony convictions. They look like they are in sequence. He is an habitual felon.
Yes.
So he's looking at 25, no less than 25, no more than life imprisonment if found guilty here. And the defendant is not here
Right.
and purportedly is,
But we did understand that he was on Zoom in the hospital in Carnival too. So he appeared, but
well, all we can really say is he appeared to be in the hospital.
That's what I told defense counsel. He's at the hospital. It doesn't mean that he is the one who's getting treatment.
Yeah, and we're going to be, look, we're going to trust, but we're going to darn well verify. So that's what we're going to do is I'm going to make some tentative findings because I trust you. I'm not trusting this defendant, but I will find that he purportedly is unable to be here today because he is in the hospital. And which hospital did he purportedly be? Was he purportedly
I'm not sure. No, I didn't see it. I'm not sure.
on the planet Earth somewhere?
right.
So the court is going to do this. I'm going to make tentative findings that he's unable to be here. So we're going to reset this case. But he is purportedly unable to be here. He must have, as soon as possible, written confirmation that he is in the hospital being treated inpatient at this time, this morning, for this court to verify his inability to be here. Failure to do so, of course, can result in a revocation of his bond, among other
Yes, sir.
sanctions. But we will note that he is at 25 to life and as an habitual felon, according to this indictment, and this court's experience in this job has shown that people facing habitual felon status can act desperately to avoid being held accountable to trial in such a case. So he must have, the court shall order the defendant to have written confirmation of his hospital status to this court within 24 hours. Failure to do so, the court will issue a warrant for his arrest and revoke his bond. We'll call it in the morning and see what the status is. Okay, thank you.
Thank you.
All right, yes, sir. What else?
I thought you wanted to hear from Booth. Let me get him to come on out real quick.
Okay, and what is this for?
He was offered 7. You revoked him on the MTRP at 4, and he's telling me that he's absolutely innocent. So,
Okay, well, I'm gonna talk him out of that.
no, I just want you to hear it. No, I don't know. No,
Where's Booth's spot on?
You had given it to me.
All right, bring him out. We can do with that. Let's see, David Booth.
I have Mr. Booth.
All right, we're back on this 26 CR 605. So go ahead. That was,
Right,
you said for an announcement. So what's our announcement?
the announcement on Mr. Booth is he's saying that he is not guilty.
Okay, we go to trial.
Yes, sir.
That's what we're gonna do. And Mr. Booth, this one's a second degree felony, aggravated assault with a deadly weapon. So you're looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range you're looking at? Let me look at one thing.
Once each lady watching, we'll be there going on. We just have each morning, 30 miles. So one lady is supposed to be served today. One says she didn't see.
Okay, who's the prosecution on that? That one? Looks like Mr. Laird. Okay.
Will get the NTRP pulled? It's in scanning. I don't have the NTRP that judge wrote on, but it's where we wrote that judge found number 5 to be true and revoked him to 4 years. So it was not an agreement.
There's not
There was
no. Look at this, as is the victim appearing, and it's obvious the defendant doesn't think she's gonna show up. I mean, we've done this enough. This is a homeless group that we're dealing with, and he's rolling the dice on she won't show up. So we're just gonna set it for trial and see what happens. That's all we can do. But you can't have any contact with the victim nor anyone on your behalf. If that happened and we caught that, that would be a new crime. And then you would be subject to more prosecution. So let the system play out without interfering. That is all. I have a Sean Craig dismissal. Do I sign that?
That was
To
on-
be dismissed, yeah, 26371. Okay, I hadn't seen, really, I hadn't seen her.
Or hardly working on that.
He always works hard.
Always.
I'll stand up for our public defenders.
You have, I don't have.
Mr. Manning on Clark.
Yeah,
He's on trial.
Oh, he's on the trial? Oh, okay, okay, no, what are you sitting around for? We don't try this thing until 1.
Oh,
You gonna bill me?
That would be the way to get paid now. But,
That's not the right way to do it.
all right.
All right, who's ready? Come on up. All right. Daniel Clark?
I will sign that, and it's just the certificate of discovery. I'll give that to you. Yeah, I'd get mine. That's just.
You laugh at whatever you wear.
Thank you, Judge.
And Nathaniel Clark,
Oh, here, please.
right there first, and then come back.
Clark, please raise your right hand.
Did you visit?
Keep it where you're talking about. Okay. I need to get your thumbprint right now. You can have one more time. Right outside the box. Perfect. Thank you.
So the music and food was off the chain.
So it's been awesome.
When I went there, I went to Avery Island, which is, I wanted to visit.
Thank you.
Explain to me what we're doing here. He's an habitual felon, right?
Correct.
Okay, so he's looking at 25 to life, but y'all are just abandoning his prior convictions and just going on the 3rd-degree felony, DWI? How do we sell that to Mothers Against Drug Driving in this county?
Well, the reason why I made the decision is because of the age of his priors and the facts and circumstances of this scenario. In addition to his particular age, I felt like justice would be best served with this agreement, Judge. And if they have any points, they can visit with me about it. I'll go into detail.
I don't know, okay? Crying and weeping that goes on in this room because of intoxication. You get wears over 20 years. And here, I mean, it's just not your first. This is your 3rd DWI. Plus you got an illegal possession of drugs conviction in 97, and then felony conviction, aggravated battery in 99. But these, it's a 2012 first conviction out of Wichita Parish, the DWI. And then after that in 2015, another conviction, and then this one. The thing is these are 4 prior convictions that you've had, and they're all serious. 2 of them are found, but now this one constitutes a 3rd felony conviction. I'm not going to handle it this way. We'll let the jurors decide what's appropriate under his circumstances. Okay, thank you. Set it for trial. All right, Jamal Mishaw.
So he's next door, Judge, all this climbs out, so.
We just ran out of room. We have it.
Okay, because I've got a cluster of his. 1, 2,
I need no problem.
3, 4, 5, 6. Okay, I was looking for Brent because I could. What about William Gardner?
Judge Mike is considering a counter offer on him. If we could have
What do you want on Gardner to do?
just a setting judge, he needs to
All right.
contact the complainant to
Tim Gardner's reset one. Thank you. But one more here. I've got Donald.
Judge, I believe my office filed for a bond reduction for him, but I don't see that notated on the docket. I know the state has to have proper notice of it, but if we could reset him a week too.
Okay. On Donald Guillory, that's Miss Moore. On Donald Guillory, it looks like, did the victim almost die in this?
No, sir,
Said surgery was required on the victim due to severe leg injury along with head injury and road rash. That doesn't sound good. And it says knowingly and recklessly caused serious bodily injury to the victim. That's got it. So there wasn't serious bodily injury?
the indictment is correct, Judge. I know he had surgery for some injuries to his leg.
Because they're asking for a reduction in bond here, and we're gonna have a hearing on that when we can, but this, to me, it's the seriousness of the injury is gonna have a lot to do with everything.
And I can speak to him more. I've spoken to him, but we didn't speak.
But I mean, it's just
Absolutely not bad.
states knowingly or recklessly cause serious bodily injuries. What are we gonna do today?
Judge, I do need to have a setting for that bond hearing, so if we could have a week resetting
I'll put it later this week for you.
here Thursday.
Okay.
I'm out Thursday and Friday.
Monday it is, Judge.
Okay.
Just 1 week.
Monday gonna be good. I think this, I don't know.
It
The
is.
day to day nowadays on this, the way things go around here. Okay. It's set for Monday for hearing Watisha.
She's asleep.
Why, but my question is, really, is why not? Man, you're Miss Jackson?
Yes.
Okay, you have to go in front of this nice lady. You should swear you in. Thank you. What's this one?
Okay. Thank you, Kendall.
Stand in front of the judge.
All right, we now call house number 24CR1903, the state of Texas versus Watisha Jackson. And it would be nice if the state's prosecutor, we can go without him, but this one was assigned originally to Kyle Gasper. We have a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, Judge.
And Ms. Minaldi is here representing the defendant. In summary, this indictment alleges that on June 30th, 2024 in Jefferson County, Texas, you committed the state jail felony of fraudulent use or possession of credit or debit card items. It's like less than 5. And that's what constitutes a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? You have a real soft voice. An agreement has been reached where you would be pleading guilty but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 5 years in length. You do well, I can shorten it to 1/3 of that if you do well. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
You're pleading guilty freely and voluntarily? Yes.
Okay, I'm showing you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence without objection. It's admitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's made. You read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty so long as you follow the terms and conditions of this probation order. You will be placed on probation for 5 years. It can be shortened by doing well. There will be terms and conditions of probation here. Make sure you follow them. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 2 years in the state jail. You must complete a theft prevention class, which is a good class to take for all persons, I think. Is there any loss here? Okay, I've signed the probation orders and do well, and we will reward you. Please see the probation officer. Thank you.
I'm just saying this. I get your sentence. It just seems.
Last call, real quick. Thank you.
This is kind of one of the.
Well, thanks.
We've seen.
Isaac Smith.
He's a plea as well, Judge.
Isaac Smith.
I'm not vicious with them.
That's, we don't have the policy where if you make that store license plate down because they don't want to go, they don't do that.
Come forward, sir. And please see this lady. Thank you. How you doing, Miss Stevens? How y'all doing?
Mr. Smith, right there.
You're the right hand.
Nothing but the stuff you got?
No.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Sure.
What are we doing?
We do that for.
Say one.
How long has he been in jail? Thank you. 26CR309 is now called the State of Texas versus Isaac Lee Smith. That's you? You're present with your attorney, and the state's attorney does. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, Judge.
All right, in summary, Mr. Laird, this is yours, I think. It's Isaac Smith, Parson.
Custody 109 days.
Thank you. In summary, this states in this indictment that on or about January 19th, 2025, in Jefferson County, Texas, you committed the first-degree felony of arson with intent to damage a habitation. Damaging or destroying a habitation with intent to damage or destroy a habitation. It looks like Cedar Ridge Apartments. You started a fire and placed it in the wooden patio of the habitation. And that was within the city of Port Arthur. Anyway, it's a first-degree felony. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed but not found guilty. You would be placed on deferred or unadjudicated probation, fined $500. Is there any restitution on this? And this deferred or unadjudicated probation will be up to 10 years. You do well and it gets shortened. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand?
So,
I told you you'd be fined $500 as well. I show you. And again, how do you plead? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? You have to speak out so she can hear you. The court reporter, you can't, if you nod, they can't take that. I'm going to show you what's marked as State's Exhibit 1. You need to sign.
Oh, did my signature? Oh, I've seen
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct? Okay, you got a soft voice. Make sure she's got to be able to take everything down. The court reporter here, she has to hear you. State's Exhibit 1 is tendered into
No,
evidence
sir.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been, you've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
If nothing further, I'm going to find that you are mentally competent to enter your guilty plea, sir. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You are pleading guilty today.
So,
Voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this first-degree felony. But I am not going to find you guilty so long as you follow these terms and conditions of probation. I'm going to defer any finding of guilt. Now, this is for a term of 10 years, but we shorten it for good behavior. I can shorten it to as much as a third. There will be terms and conditions of probation. The probation officer will go over these with you here in a moment. Make sure you follow them. If you fail, your probation can be revoked. You can then be found guilty and sentenced in for this particular case. You are looking at any term no less than 5 years, no more than 99 years confinement or life imprisonment. So it's a very serious situation.
Thank you.
He's got how much time now?
Judge, he's been in custody for about 9 days.
A couple of things. The affidavit that was filed stated that this was a second-degree felony, but intending,
Because of the habitation element. Because of the habitation element.
because of the habitation, it's a first-degree felony.
Correct.
And that's how it was indicted by the grand jury. And it says, knowing that would endanger the life of an individual as the apartment was occupied and the fire caused damage to the wooden railing, and as apparently a video depicts the defendant doing all of this. All right. Here's the point. Even though there's enough evidence to find you guilty, again, I am deferring or postponing any finding so long as you follow the terms and conditions of probation. You have been in jail 109 days. You're going to be ordered to do 71 more days. I can order anyone as a condition of probation. God bless you. To serve up to 180 days in the county jail. And it's for this, I hardly ever do that. But when you attempt to burn down someone's home, that is as serious as it gets. Thus, this court would be failing its duty under its oath it takes to see that justice is done. If I did place you under the 180 days requirement, because this is a serious thing to burn someone out of their home, attempt to. I can't think of too much more serious than that. And the court's orders must reflect the seriousness of this by its orders. So you're ordered to do an additional 71 days in jail to complete 180 days. If you fail, though, on probation, I hope you don't, you're looking at life imprisonment. Do you understand what's happened? Fix this. He's not, for the record, he's nodding and not speaking out.
Yes, sir.
Like I've asked him to do. But
Yes.
on the record, he nods. He understands. All right. Good luck. That is all.
It's very good.
Is that it for you?
That's all I have, Judge. Excuse.
Kelvin, yes, ma'am. Kelvin Anderson.